Good morning, friends. My dear and respected colleagues in legal profession, learned senior members of the bar, my fellow citizens. Today, I am before you to speak about the latest judgment of the Honorable Supreme Court on the special intensive revision whether Election Commission has got right to do so. So, on that subject, I am expressing my views. The SIR judgment and the future of Indian democracy, citizenship, constitutional morality, and the role of the judiciary. Democracy cannot survive if citizens must constantly prove their right to belong. My friends, it's not a mere discussion about an electoral issue, but I am speaking about the future of the constitutional democracy in India. The judgment of the Honorable Supreme Court in Association for Democratic Reforms and Others versus Election Commission of India in WP number 640/2025 and connected cases, judgment dated 27/5/2026, upholding the special intensive revision SIR of the electoral rolls done by the Election Commission of India has generated profound constitutional concern across the country. With due respect to the Honorable Supreme Court, I disagree with the judgment. The controversy surrounding the special intensive revision process is not just about voters list, my friends. It concerns citizenship, democratic participation, constitutional morality, and the institutional responsibility. India became a great democracy because of our constitution adopted universal adult franchise from the very birth of the republic. At a time when many nations still imposed restrictions based on property, literacy, or race, India declared that every adult citizen, rich or poor, educated or uneducated, upper caste or marginalized, possess equal political dignity. That revolutionary constitutional vision was shaped by none other than Baba Saheb Dr. B.R. Ambedkar. The vote was not merely an administrative entitlement, my friends. It was recognition of equal citizenship. No one disputes that electoral rolls should be accurate. Fraudulent entries must certainly be removed. But the constitutional question is this, my friends. Can millions of ordinary citizens suddenly be treated as doubtful participants in democracy and compelled to repeatedly prove their legitimacy merely to retain the right to vote? If Aadhaar cards, voter IDs, ration cards, and state-issued records are insufficient, then what constitutional scrutiny remains for ordinary citizens? The burden of such scrutiny does not fall equally upon the society. The wealthy and privileged may survive bureaucratic demands easily, but the migrant laborers, poor villagers, SC, ST, OBC and minority communities, displaced families, elderly citizens and marginalized people often lack perfect documentation because the state itself historically failed to maintain inclusive systems. For them, the documentation becomes not merely a procedural issue, but a question of political survival. This is why many constitutional experts fear that the process resembles a localized NRC, National Register of Citizens, through administrative means. In a democracy, citizens choose governments. Government cannot choose citizens. That is the foundational principle of constitutional democracy. At this stage, I wish to make a respectable constitutional principle, a respectable constitutional appeal to the higher judiciary, more particularly the apex court of India of this country. The Supreme Court of India is not an ordinary institution. It is the final constitutional protector between the citizen and the arbitrary power of the state. Whenever democratic rights appear vulnerable, citizens naturally turn towards judiciary with hope. That's why Senior Advocate Prashant Bhushan reportedly described this judgment as a dark moment for the judiciary because, according to the critics, the constitutional implications of mass disenfranchisement and citizenship suspicion were not adequately addressed in this judgment. One of the petitioners in this case, Yogendra Yadav, observed that the constitutional challenge gradually shifted away from rigorous constitutional scrutiny into grievance management after the process itself was allowed to continue substantially. His concern was simple but profound. Once millions are excluded from the democratic participation, later remedies become meaningless. We may agree or disagree with these criticisms, but we cannot ignore the growing public anxiety that the constitutional institutions must remain visibly independent from the executive or the government influence. History places a solemn responsibility upon the judiciary. The judgment in ADM Jabalpur versus Shivakant Shukla became a painful reminder of what happens when constitutional courts fail to fully defend the liberty during the moments of executive excess. Later generations of judges themselves acknowledged that constitutional mistake. Today, nation once again looks towards the higher judiciary with hope, not for confrontation with the government, but for fearless constitutional scrutiny consistent with the constitutional morality. The judiciary derives moral authority not from the political approval, but from public confidence that it will stand firmly with the Constitution during difficult times. The Constitution of India begins with the words, "We the people of India," not "we the government," not "we the powerful." The Constitution belongs to equally to the weakest citizen standing silently in the last line of the society. Democracy survives only when that citizen feels secure, included, and respected. If citizens begin to fear exclusion from democracy itself, then the constitutional alarm bells must ring across the nation. Therefore, this movement demands constitutional vigilance, institutional courage, and peaceful democratic resistance guided by liberty, equality, and fraternity. Thank you, my friends. Thank you.